Welcome. My name is Marcus Fuller. I am a labor relations specialist on the Accountability and Workforce Relations team here at the U.S. Office of Personnel Management. It gives me great pleasure to welcome you to today's webcast training entitled the FLRA Case Law Update. Our office presents webcast trainings in support of our ongoing effort to bring relevant and reliable developmental opportunities to federal sector employee and labor relations practitioners. Our speakers will discuss fiscal year 2019 decisions from the Federal Labor Relations Authority. The case law is updated as of December 5th, 2019. If you have any questions about the training, you may send an email to awr@opm.gov. We will do our best to field as many questions as possible. Please note that your webcast instructions also included a SurveyMonkey hyperlink to an evaluation form. Simply click the link, follow the instructions, and your valuable instant feedback will be sent back to us. We are pleased to have as today's speakers Amanda Gill and Amanda Jones from OPM's Accountability and Workforce Relations Policy Office. Amanda Gill is currently serving as a labor relations advisor. She has over 25 years of federal service, including significant experience in employee relations, in addition to her labor relations expertise in the interpretation and application of labor agreements. Amanda Jones is currently serving as a human resources specialist labor relations. She provides policy guidance and technical assistance to agency labor relations practitioners and attorneys. Please join me in welcoming Amanda Gill and Amanda Jones.
All right, thanks so much, Marcus. And welcome, everybody. Thank you so much for joining us here today. My name is Amanda Jones, and yes, you heard that right. We are both named Amanda. This is Amanda Gill to my left. And today we're here to talk about the FLRA case law update. I know we have 2019 in the introduction on these slides, but we're actually going to give an overview of some of the 2018 cases that we felt like were particularly significant and that practitioners and attorneys should know about. So we will be talking about both 2018 and 2019 significant cases today. And I will turn it over to Amanda for some introduction on the statute.
Thank you, Amanda. I'm sorry, we won't do that the entire hour because we realize that might get to be a bit too much. However, thank you for joining us. We know the next hour you guys are you've been anticipating this hour for a long time. I have. So we're going to move on to Federal Service Labor Management Relations Statute, right? Also known as 5 U.S.C. Chapter 71. The statute, also fondly known as the statute, and which is what actually the reference I'll probably use most of the hour. So the statute defines the rights of employees, labor organizations, and agencies. And I think the piece that really has been renewed focus is in holding the highest standards of employee performance and efficient government operations. This is found in 7101 A and B. Actually, the second bullet is also located in B. So this is really under Congress fines. This is the intent of Congress. And in 7101B, the last sentence actually says that the statute should be interpreted in a manner consistent with the requirement of an effective and efficient government. And as LR practitioners, if you've actually seen a lot of the case law that's come out since last year, you've seen a very renewed focus on that particular language. This language is also cited in the workforce executive orders, primarily Executive Order 13836, Section 1, and 13837, Section 3. So the second slide, basically the relevant provisions, right? These are, as practitioners, we probably really know the statute inside and out. And if we haven't, we will probably get to know it inside and out. But these following sections are the relevant provisions for many of the cases that we're going to actually speak to over the next 55 minutes now. All right, first case. The first case is a 2018 case. I think almost everyone's probably heard about this. But before we actually focus on the substantive matter of the case, I think it's probably important to have a little bit of history and context as to what the authority had previously cited as a management rights framework when it came to arbitral decisions. So up until 1987, the authority used multiple approaches in addressing arbitral authorities. And when I say multiple approaches, in some instances, if the grievance interfered with the management right, a 7106A right, the authority would consider it to be not arbitrable. However, in other instances, if the arbitration award was not precluded from being addressed by an arbitrator, if the remedies fashioned by the arbitrator provided no requirement beyond what was specified in existing law. So yes, a little bit confusing, and actually got a little more confusing, at least in my opinion, over the next decade or so. So in 1988, in Social Security Administration, the authority concluded that restrictions found in 7106A on the remedial authority of arbitrators was not warranted as long as the arbitrator found that the agency had violated law, rule, or regulation. So what does that mean? That basically what it meant was that the arbitrator's authority to substitute their judgment for that of management if fashioning a remedy for a violation was beyond restriction. So basically an arbitrator could do what they wanted to do in fashioning an appropriate remedy. The Supreme Court, however, rejected that view. And in Department of Treasury, IRS versus FLRA, Justice Scalia basically clarified that when an agency acts pursuant to a management right enumerated in 7106A, it is insulated from the grievance requirements of 7121C. And the authority seemingly ignored, or continued to ignore this case for about another 7 years, until we get to Bureau of Engraving and Printing. And in BEP, a 2-member quorum revised their framework into a 2-prong test to determine when an arbitrator's award adversely affected a 7106A right. And in the first prong, the authority found that an arbitrator award that affects management rights may provide remedy only for a violation of either applicable law or for a negotiated provision under 7106B in a collective bargaining agreement. And under the second prong, the authority decided that it would analyze whether the remedy for such a violation was basically a reconstruction of what would have happened had the violation not occurred. So what the authority said was that if there was a violation, did the arbitrator basically fashion a remedy that would have actually been what the agency would have done had they actually not violated the contract. And under that framework, the reconstruction provision actually stood for a while. And the authority basically followed BEP until about 2010. And in 2010, the authority jettisoned reconstruction, and then we had FDIC and the EPA cases, which you actually see at the bottom of your slide. And basically, in FDIC and EPA, the authority focused on the remedy and not as much the violation of 7106A rights. In FDIC, quite simply, what that basically stated was that it established an award imposes a constraint on management's rights if the provision that was violated was not agreed to by the parties. So in other words, if it was not negotiated, then the award would have been set aside. And then in EPA, that also focused primarily on remedies. And if a provision was negotiated pursuant to 7106B, an arbitrator's award could only be contrary to law if the award entirely abrogated management's rights. In 2012, the U.S. Court of Appeals for the D.C. Circuit called for the authority to abandon the abrogation standard and return to the excessive interference standard. And in that vein, what they said, actually there was a very, very distinct conversation with the court when they said that 7106B was really, the only way that should have been applied was if the agency chose to bargain or not to bargain over that particular matter, and reliance on a 7106B negotiated provision when it came to arbitral awards really was nonsensical. And so that brings us up to this current case.
Okay, great. So this is the BOP case that's on your slide that we're going to be talking about, and that's going to kind of set the stage for the FLRA coming up with this new management rights framework that you also see on your slide. So before we get to the actual new management rights framework, I'm just going to go over the facts of this particular case. So the agency in this case provides medical services. They are the Bureau of Prisons. They provide medical services for over 200,000 federal inmates. They actually have two types of employees that provide these medical services. They have bargaining unit employees, which are covered by the CBA in this case, and they have another set of employees that are non-bargaining unit because they're in the uniform service, and those are under the U.S. Public Health Service Commission Corps, so we'll call those PHS officers or non-bargaining unit employees in this case. So we have those two sets of employees working together in these medical services. And just for a little background, those officers, the non-bargaining unit employees, make up about 24% of the medical service employees unit, so it is pretty significant. The union filed a national grievance in this case, alleging that the agency violated actually two articles in their contract. One article involved scheduling and the bidding process and the rosters and how the correctional staff would bid for assignments, days off, shifts, that kind of. So it's involving all of the work schedules bidding. They said that the agency actually set aside a number of assignments, days off, shifts for those non-bargaining unit employees before they let the bargaining unit employees bid on them. The second alleged violation of the article was the article about vacation days, and similarly, they said the agency set aside slots for those non-bargaining unit employees to bid on the vacation days. So the arbitrator in this case actually said, yes, the agency did violate the contract, and the award was, and the arbitrator decided that the agency should stop violating the contract, should stop withholding those assignments, days off, vacation days, in order to set them aside for those non-bargaining employees. So the agency filed exceptions and argued that the arbitrator's award violated their right to assign employees and assign work under 7106 of the statute. They said they have a right to determine where employees will be assigned and what assignments it will offer to bargaining unit employees for bidding. The FLRA decided that they're going to make up this new framework to determine whether an arbitrator's award violated a management right. So we'll go through that framework using this case right now. So the first question the FLRA is going to ask is, did the arbitrator find a contractual violation? If not, then if there was no violation, then they're going to vacate the award. If yes, move on to question 2. Does the remedy reasonably and proportionally relate to the violation? If no, award is vacated. If yes, then we're going to move on to question 3. Does the arbitrator's interpretation of the provision excessively interfere with a 7106A management right? And if it does excessively interfere, then the award is vacated. So to apply the facts of this case, the arbitrator, they agreed that there was a violation of the contract here. So 1 was yes. So moving on. 2, the remedy was reasonably and proportionally related to the violation. So the remedy was you violate the contract, don't violate the contract, basically. But number 3, they found that the arbitrator's interpretation of this contract provision excessively interfered with the agency's right to assign work because, as the agency argued, it restricted their ability to assign work to employees outside the bargaining unit. So therefore, that portion of the arbitration award was actually vacated. So that's the BOP case. And then we will also apply that same set of management rights frameworks to some other cases that have come up. The first bullet is, again, the BOP case, which I just went over. So the agency violated the contract. These are the 3 questions. 2, the remedy was reasonably related to that violation, but they found there was excessive interference with the management right. In the CBP case, the DHS case, second bullet, what happened in this case, there was a grievant was arrested for driving under the influence of alcohol while carrying a firearm. So at the agency, they have the ability to carry out what they call an expedited investigation, but they don't have to use that. So in this case, the agency argued that, well, the union filed a grievance on behalf of the employee, and the agency argued that, the grievant wasn't eligible for this expedited process, and that it was okay that the investigation took 14 months, and that the union also said, hey, it's supposed to, you're supposed to use the expedited investigation process, and you have to provide the grievant with a disciplinary notice as soon as practicable. The arbitrator found the agency violated the contract, and the arbitrator actually awarded the grievant 12 months of back pay for missed overtime. The FLRA applied this new management rights framework, which you can follow on the slide previous to this. So it really centered on that second question. Was the remedy reasonably related to the violation? The FLRA said no. The remedy of 12 months of back pay for lost overtime was not related to this violation of not providing notice at the earliest practicable date. The FLRA said the agency did not have to use this expedited process, and basically 12 months was completely unreasonable, so they vacated that award. The second case also turns on the second question of the framework. In this case, the arbitrator concluded that the agency violated a telework provision in the CBA when it did not provide a sufficient explanation for why the grievant was denied telework full-time in a different city. So the arbitrator awarded that the grievant would be allowed to telework from the different city and provide this grievant back pay. The FLRA held that this was disproportionate, this award was disproportionate to the contract violation, so it was unreasonable. And again, we're focusing on that second question of the framework. The FLRA said the agency's failure to provide the grievant with a specific justification of the denial would entitle the grievant to, at most, just a more specific justification. So instead of allowing the grievant to telework, the award should have just been give them a better reason, really. And then the fourth bullet is another BOP case. This actually, again, turns on the third question of the management rights framework. So in this case, the arbitrator held that the agency violated the party's CBA by failing to staff the third floor of these housing units in a prison. So the remedy was the arbitrator said, okay, agency staff the third floors. The FLRA found that the award excessively interfered with the management right to assign work and determine internal security. So they said, the FLRA said, by requiring the agency to staff the third floor, to always staff the third floors of these units, the arbitrator denied the agency the ability to determine how it should staff the prison and substituted judgment for that of the agency on how best to safeguard the prison. So those are all the cases about the new management rights framework and sort of how to apply that. So we'll move on.
So that would be
Yeah.
So it was like a mouthful on management rights framework,
Yes,
right?
it's a lot.
Between, and actually the historical context that, I put on that, or like discussed in that slide, is discussed in the case. So It's not something that I would get in 5 minutes, so I really don't expect that everybody else would necessarily get that. But if you read the case, you will be able to actually get all of that information. So moving on to 70 FLRA 501, which is the Customs and Border Protection case, El Paso. I think basically everybody I know that works in LR has heard of this case. It's really where the authority has now made a distinction between working conditions and conditions of employment. Really short background. So in this particular case, Border Patrol agents inspect vehicles gaining entry into the United States. And agents work in a primary inspection area and have the discretion to send vehicles to a secondary inspection area. On any given day, the agents could be assigned to the primary, the secondary, or both inspection areas. So it is part of established duties. And at some point, the division chief issued a memo establishing parameters under which he wanted vehicles to be directed to the secondary vehicle inspection area because he had established that there were some failures in light of being able to detect fraudulent vehicles or documents. So he wanted actually a greater frequency in the second inspection area. Of course, the union filed a grievance saying that the agency had changed conditions of employment. Arbitrator agreed and ordered that the agency maintain status quo until they had bargained the impact and implementation. Now, in this particular case, as I said, the authority actually has now taken a category of basically situations out of conditions of employment, which they define as working conditions. So to be clear, the authority didn't redefine conditions of employment, but basically what the authority has said is that the day-to-day circumstances under which an employee performs his or her duties are not conditions of employment. Instead, they're working conditions. So they basically mirror increases and decreases, but performing the nature and type of duties have not changed would be conditions of employment. And it's probably one of the simpler cases to talk about distinction. Now, I know there's been a lot of questions about this, so I'm going to let you take that.
I think in part because the FLRA didn't really expand a lot on their decision here in the El Paso case. But we've already received questions about, since the El Paso case, has the FLRA done anything to elaborate on what it thinks does and does not now count as a condition of employment? I would say not really, but there have been references to El Paso that
it depends.
Yes, it depends, of course. I think, but there have been references to El Paso since El Paso, and so we can use those to kind of pick apart this decision a little bit and see what the distinction is. The first one I wanted to point you to is actually from June of this year, 2019, and it was National Institute Standards of Technology and FOP, and that was 71 FLRA 199, and that's not on your slide, but again, that's 71 FLRA 199. This case involved law enforcement officers, and the agency had a problem where they didn't have enough supervisors to cover each shift without incurring overtime. So the police chief here developed a new policy which established additional tasks for non-supervisory, like the senior-most non-supervisory bargaining unit employees to perform basically in lieu of a supervisor not being on that shift. So they would do things like stepping up in the absence of supervisors, completing certifying time and attendance, contacting other supervisors if a problem arose. So just, kind of some supervisory duties. The union filed a grievance alleging that the agency implemented the policy prior, they made a change without negotiating. The arbitrator agreed with the union, determined that the change, that it was a change in conditions of employment, and it was more than de minimis. The El Paso case reference here was actually in a footnote. It was in the FLRA case, it was footnote number 3. And they noted that while not raised by the agency, meaning that the agency didn't make the El Paso argument, probably because I don't the timing of this case, but it wasn't raised. But the FLRA said, while not raised by the agency, we take this opportunity to note that changes enacted in this policy are, in fact, changes of conditions of employment, not working conditions, in contrast to El Paso. So we can see here a case where there is a distinction between a new policy in this NIST case that I cited and the El Paso case that was not a change in conditions of employment. I think the distinction here we can make is that the policy, the law enforcement officer's policy in this NIST case really just fundamentally changed the nature and types of duties of those senior officers who were bargaining unit employees. It essentially gave them supervisory duties and responsibilities, and it pushed those duties down to them. So they were new duties. They weren't just the nature and type of duties. They weren't just how their same duties would be performed. They were new. So I think that's a good distinction to make between these new kind of work-related policies between this case and El Paso. and that was the last case, I believe, that mentioned El Paso. There were some cases in 2018. There was a SSA case, 70 FLRA 759. And in this case, the FLRA actually remanded the case back to the ALJ to apply El Paso. So this was a case where actually ALJs were assigned, at the SSA, were assigned clerks, and the agency changed the policy where they changed the way the clerks were assigned work. So instead of having a clerk per ALJ, they kind of formed these teams. The agency argued they had no duty to bargain because it didn't change the ALJ's condition of employment. It really just changed the clerk's conditions of employment. So the judge found that it actually did change the ALJ's conditions of employment. And when it got to the FLRA, because the ALJ hadn't had the opportunity to apply El Paso, they remanded this back. So we'll see what happens with that one. And then finally, there's another case I just wanted to point out for another footnote. NTU and FCC is 70 FLRA 691 and again, that's 70 FLRA 691. That's from July 2018. So this case is actually a negotiability appeal, and the proposal here was for the agency to adopt security procedures for a building, the same as the security procedures from like another building for another part of the agency. The agency argued that it excessively interfered with management right to determine internal security practices. FLRA agreed. But the interesting part involving El Paso in this case was in footnote 31, when Member Abbott adds that that it's important distinction that the agency should have raised the condition of employment and no duty to bargain argument, because any determination, he said, that concerns the internal security of an agency and property is a right that belongs solely to the agency and by its very nature does not impact a condition of employment. So I think that really opened the door for agencies to make that argument more. And those are the cases that we thought we'd point out for the El Paso case. Okay, so moving on. Anything you want to say about El Paso?
No, I think we said quite a bit.
Okay. Yeah, so basically it's, we'll see what happens. It'll be applied sort of on a case-by-case basis, and we'll just see. Okay, so moving on to the next slide, this SBA case. This is actually a change in precedent. It's a pretty clear holding we have here on the slide for you to take away, easy to remember. Very quickly, the facts of this case. So 6 months after invoking arbitration on a grievance, the union submitted this standard form to request a panel of arbitrators from FNCS, and they had to submit that form to the agency. So the CBA actually said very clearly that that form had to be submitted within 14 days. So here we have the union submitting it 6 months after invoking arbitration, where the CBA said it should have been submitted within 14 days. The arbitrator actually determined that the grievance was arbitrable. He found that the agency waived their right because they accepted the form. And even if they had objected on timeliness reasons, the parties had a past practice of not strictly complying with those time limits in the CBA. So maybe in the past they've accepted this form, a few months after, beyond the 14 days, essentially. The FLRA re-examined their prior precedent on 2 issues. So they held the arbitrator's determination that the grievance was procedurally arbitrable conflicts with the plain wording of the CBA, and therefore the award fails to draw its essence from the agreement. So parties may now file essence exceptions that directly challenge arbitrators' procedural arbitrability determinations. And I think the more significant holding in this case is that arbitrators now may not rely on past practices to overrule this clear and unambiguous provisions of CBAs. So when it's there in black and white and it's clear, an arbitrator can't go in and say, no, there's a past practice not to follow that. The FLRA noted that this rule provides parties with stability because now they're able to rely on the actual written agreement and nothing beyond that. All right.
Right. So moving on, the next slide is Department of Transportation, Federal Aviation Administration. So this case centers around the exclusion of confidential employee, or what we define as confidential employee. I think everybody's familiar under 7103A13. A confidential employee is basically an employee that acts in a confidential capacity with respect to an individual. I don't remember where I get this. With respect to an individual who affects policies as related to labor management relations, right? That might not be the exact text because I can't really remember everything, but generally that's how we would define a confidential employee. And in the past, the authority has always sort of held that it's not only, the duties that are in a position description, but it's the actual duties that are performed by the individual that actually would meet the exclusion for a confidential employee. Well, actually now there's actually another twist to that. So in this particular situation, the authorities ruled that future duties may be considered in determining whether an employee meets the definition of confidential employee. So in this particular case, the agency and the union had filed clarification of unit petitions. And just what's relevant here, I think there were quite a few positions that were a part of the petition, but for this particular issue, what's relevant are 3 categories of positions. It was administrative officer, administrative services specialist, and administrative specialist positions. So in this particular matter, the regional director in D.C. of the authority found that 4 employees that encumbered these 3 positions were not confidential employees as defined in the statute. And the authority granted the agency's application for review. And in this particular case, there was no dispute that the manager or the deputy regional administrator, who these folks reported to, would be involved in significant labor relations matters, including negotiations with the union, defending grievances, ULPs, and these admin support positions would be responsible for dealing with those issues to support the regional director, but they had not yet performed any of these types of activities. So in this circumstance, the authority did grant that those duties, which an employee would reasonably be expected to perform should they arise, because the individual they report to has significant labor management relations responsibility, would be considered to be confidential for this purpose. So what the authority specifically said was that they will look at not only the position descriptions, actual duties identified, but the supervisor's determination of the duties of the confidential employee. So in this particular situation, I think the authority equated to, for example, if you're a facilities manager at an agency and you have a fire station, but yet you've had no fires, so you've had no need for firefighters to actually do their jobs, doesn't make them any less responsible for safety. And
They're just lucky.
yeah, exactly. They're lucky there have been no fires. So in this instance, and actually I'm surprised that they have not yet had any labor relations activity, maybe looking for a job soon. No, I'm just kidding. So in this particular instance, the definition of confidential employee was expanded as to what someone may do in the future.
Yep.
Oh, yes, it's me. I've got the next one too. U.S. Department of Energy, Western Area Power Administration. So in this particular situation, the agencies had difficulty retaining power system dispatchers, and Congress had given the agency sole and exclusive authority to set rates of basic pay and premium pay, notwithstanding provisions of Title V of the U.S. Code. So the agency has exercised this authority since 1989. Union filed a grievance on behalf of some employees who alleged they were not receiving the prevailing rate of pay for work that they performed and for holidays, and the agency denied the grievance, of course citing that they have sole and exclusive, and it would not be subject to the negotiated grievance procedure. However, arbitrator rejected the agency's argument, citing the important functions of the negotiated grievance procedure in the federal sector. And further, the arbitrator found the agency failed to provide dispatchers with prevailing holiday premium, and he awarded the grievance back pay. So he made and adding insult to injury, he made the agency responsible for 2/3 of the attorney's fees and only 1/3 to the union because the union was successful in the majority of their grieved actions. However, so when we talk about sole and exclusive, right, the language that Congress gave, it said notwithstanding Title V. Now, the agency would not be obligated, right, to be held to statutory requirement under Title V when you apply the grievance procedure. However, the authority in its wisdom in NTU Chapter 302, and that particular case is not on the slide, but it is a 2011 case. It's 65 FLRA 746. The authority held that once an agency exercises its sole and exclusive discretion to establish an employee compensation system, individual applications of that system may be subject to the grievance procedure. So what did they say? Yes, agency, you have the authority, notwithstanding Title V, to establish pay, to the rate of pay, the premium pay. Mm-hmm. However, now that an individual claims that they didn't get paid appropriately, they can grieve it. So in essence, you do get to apply, right, Title V. So in this particular instance, the authority is now reverse precedent, and they're saying that it's untenable, right? If you're giving them sole and exclusive discretion, then to allow the application of Title V to prevail. So in this particular case, the authority says, we overrule previous decisions that distinguish between establishing and applying compensation systems in the context of sole and exclusive discretion. If an agency's discretion over a matter is sole and exclusive, then the exercise of that discretion is not subject to negotiations or grievances and arbitration. And the award was set aside.
All right. Okay, so kind of moving on to a fun one. This is a little, no, not really.
It's sad. We consider this fun.
Yeah, maybe some of you actually think this is fun. This one's a little more complicated. Because it involves both the Federal Service Impasse Panel jurisdictional issue and also a procedural dismissal of ULP complaint issue. So just to make it a little more tolerable, I'm going to break those two issues up, and we broke it up into 2 slides, actually, to be a little bit helpful. Okay, so what happened in this case? This is a DODEA case in earlier this year. So the parties were negotiating their CBA. They reached tentative agreement on 22 articles. So remember, tentative agreement came before they went to the panel. In this case, that's relevant. So after that, the union requested panel assistance. They moved on. They reached tentative agreement on some more provisions. They had a couple articles left. So the facilitator of that came in with the panel assistance then became the fact finder, and he developed a report for the panel. So he submitted this report to the panel. He recommended no changes to an article about hours of work, and that the language was negotiable, and recommended that the parties incorporate all tentatively agreed to provisions. So the agency objected to the fact finder's recommendations on the articles that he found negotiable, but they didn't object to incorporating the tentative agreements. More than a month after the panel's decision came out, so the panel also ordered the fact finder's report, so they recommended the provisions which the agency objected to because they were non-negotiable, and they recommended the tentative agreements be incorporated. So, more than a month after this panel decision, the union wrote to the agency and asked it to implement the agreement. The agency refused, and of course, the ULP process started. A ULP charge was filed. The FLRA regional office issued a ULP complaint against the agency, and the authority found, in this case, that they determined that the panel imposed contract language on hours of work that, remember, the agency objected to of the fact finder and panel, was found to be non-negotiable because it interfered with a management right to assign work. So the authority directed parties to resume bargaining over the matters addressed in the disputed articles. So they actually found what the panel said was negotiable was actually non-negotiable because it interfered with the management right. And then the second issue here, the FLRA determined that the panel also exceeded its authority in this case because it ordered the 2 parties to incorporate those tentative agreements that I mentioned that were tentatively agreed to before the panel assistance. And they said the panel's jurisdiction only extends to matters over which the parties are at impasse. So the matters that went to the panel, so nothing before that. So it does not include those 22 articles that were tentatively agreed to. Okay. And that was the panel issue. And then the second issue is this ULP kind of procedural issue here. So the agency here argued that the ALJ in this case should have dismissed the ULP complaint because the complaint actually did not contain a negotiability allegation, meaning the ULP complaint should have alleged that the panel decision concerned negotiable contract wording. So it didn't have anything about the negotiability aspect of this. They brought up this case that we have on the slide here, Fort Rucker, and they said that Fort Rucker the agency argued that Fort Rucker holds that that negotiability allegation must be included in the ULP complaint, and if it doesn't, meaning that if that's not what Fort Rucker stands for, then it was wrong and the authority should reconsider it. So either way, they're right. That's what they're saying. The authority didn't agree with the agency's Fort Rucker analysis here and argument, but they did agree that it should be looked into and it does lack clarity. So they did They did change their mind on that one. So they said from now on, ULP complaints for the general counsel need to specifically plead negotiability if it concerns that. So the FLRA basically overruled that portion of Fort Rucker that held that the general counsel need not specifically plead negotiability. But like I said, in this case, because the general counsel in good faith relied on Fort Rucker, the FLRA holding in this case would only be used prospectively. So in all future cases, the FLRA will require the GC to plead negotiability to avoid a procedural dismissal. Okay.
All right, moving right along. Next case that we have for you is DOD, U.S. Marine Corps Air Ground Combat Center, 29 Palms, California. So in this, you just made a comment about authority changing in their mind. I really never thought I'd see that until recently. Now we actually see the authority changing their mind
Yeah, a lot.
quite a bit. Did not think I'd see that in my career, but that's just a personal note. So going back to the case on your screen, the authorities procedures at 2429.11, so it's under process, it's about interlocutory appeals. And for those of you that might not know, generally interlocutory appeals, the authority will not address interlocutory appeals because the matter is still in front of an arbitrator for a final decision. However, in this particular case, the authority changed their mind. Imagine that. So in September of 2017, the union filed a grievance alleging the grievant was performing duties outside her position description and at a higher grade. And as a remedy, the union had requested that the grievant be promoted to a GS9 position, awarded back pay. Agency denied it, alleging or claiming that it was a classification matter and it could not be grieved. The parties were not able to resolve. It went to arbitration, and the arbitrator issued an interim award in which she determined, among other things, that the dispute before her was arbitrable. In particular, she stated that there was, quote unquote, insufficient and conflicting evidence as to the exact nature of the grievance. Now, the arbitrator added that she would not consider at arbitration classification issues excluded under the parties' agreement. Rather, she said that she would consider how duties were assigned to the grievant, were they properly detailed, temporarily promoted, or compensated in accordance with the agreement. Of course, under 7121C5, arbitrators lack jurisdiction to determine the classification of any position that did not result in the reduction of grade or pay of an employee. So basically, this particular grievance seeks a promotion due to the alleged performance of duties, of higher graded duties, and the authority said regardless of how the arbitrator had characterized the dispute, the essential nature of the grievance did concern classification, and the award was set aside. Oops,
Got it.
sorry, you want me to
Thanks.
Sure.
Okay. All right. Here's another Department of Homeland Security case. So, really quick, this can be a quicker case, and I'll go over. I think the more important takeaway from this case is that second paragraph, that last sentence we have on the slide here. So I'll go over that. Basically, the facts of this case were. The agency issued 3 officers memoranda informing them that they were under investigation for misconduct, and the memorandum also advised the officers that they were being temporarily restricted from certain work-related activities, such as telework, overtime, credit hours, holiday work, that kind of thing. The union filed a grievance. They said that it was illegal under an agency regulation to restrict the agency to issue these memorandum because the agency is restricted to only 3 types of letters, 3 types of corrective letters, sorry. They also alleged due process violations, and the arbitrator denied the grievance. The FLRA here agreed with the arbitration, that the agency regulation does not prohibit these anything beyond those 3 corrective letters, so the memorandum was okay to send. And what's interesting here is the union argues that these restrictions on those temporary work-related the temporary restriction on those work-related activities can only be imposed as discipline after the conclusion of the investigation. But the FLRA said, although taking away those work-related privileges had an adverse effect on employees, there was nothing to determine that it was actually disciplinary in nature. So the agency could do that. The FLRA also clarified, which I think is the takeaway here, that agencies do not have an unfettered right to impose temporary restrictions anytime an employee is subject to any investigation, which may result in any form of discipline. There must be legitimate government interests that connects this the restrictions and the actual charges. So in this case, the FLRA found there was a reasonable connection between those charges and actually restricting those work-related activities, because the agency could reasonably question the grievance judgments and trustworthiness. I think one of the charges was like a drug-related offense, like bringing drugs to a federal facility or something like that. So in this case, it was okay, and they connected those, taking away those work-related privileges and the charges. And then our final case,
Yay.
very exciting, on attorney's fees, which we may see come up again, so I think it's pretty relevant. The FLRA, this was interesting because the FLRA solicited amicus briefs here from interested parties, and they got 10. So it did seem like, an important case to the FLRA and, to other interested parties, obviously. So the facts in this case, just very quickly, basically the arbitrator found the agency should have been providing environmental differential pay to some housekeepers. So the arbitrator awarded back pay, but the arbitrator denied the union's request for attorney fees because there was no provision for attorney fees in their CBA. So beyond, the agency arguing that they shouldn't have to provide environmental differential pay, we'll focus on the attorney's fees issues here. The union argued that the award was contrary to the Back Pay Act. And then if we kind of go through the litany of U.S. code that's involved in attorney's fees, so kind of stick with me here. The Back Pay Act notes that arbitrators' awards may include an award of back pay under 5 U.S.C. 5596, and that may include reasonable attorney's fees. So 5596 includes a provision that attorney fees must be in accordance with the standards of MSPB standards for attorney's fees, which is 5 U.S.C. 7701. And the MSPB will only award attorney's fees if certain requirements are met. One of those being the attorney fees must be warranted in the interest of justice. So how do we determine what the interest of justice means? That's sort of a very broad phrase, I think. So there's actually a case that's relied upon from 1980 called Allen v. Postal Service. The FLRA reaffirmed their reliance on the factors in Allen v. Postal Service, and there were actually 5 sort of categories and factors in Allen that in a traditional disciplinary case you can use to go through the analysis for attorney's fees. But in this particular type of case, the aggrieved action is not actually disciplinary in nature, so the FLRA said this interest of justice analysis should only focus on 2 of those 5 categories in Allen. The first being whether the agency knew or should have known at the time it denied the grievance that it would not prevail at the arbitration, or B, prior to the close of record at arbitration, compelling evidence that the agency's position was clearly without merit. So those are kind of the two factors that they'll look at for attorney's fees. And as far as knew or should have known, that standard is, attorney fees may be warranted if, for instance, the agency was negligent in taking the degree of action, it lacked reasonable and supportable explanation for its position, and then if the attorney fees if the agency's position, is clearly without merit, that standard will focus on the actual result of the arbitration. So the arbitrator will have to look at the totality of the circumstances for that case. So there's a lot of different factors for that. So here I think, so that's kind of the two standards that are the takeaways from Allen that the authority reaffirmed, that for non-disciplinary grievances, such as this case, they'll look at those two things for that interest of justice standard. And then just to conclude, I think Member Abbott had a pretty interesting point in his concurring opinion, which we've seen, a lot of interesting dissenting and concurring opinions recently. But he actually believes that OPM's regulatory definition of unjustified or unwarranted personnel action, which is kind of the definition that extends the Back Pay Act to matters other than pay matters, is inconsistent with congressional intent of the Back Pay Act. So he thinks it should be just restricted to these pay matters, which is interesting. So that's our last case. If you have any questions, as Marcus told you earlier, hopefully you are sending them to AWR. And are there any questions? I'll ask our executive producer back there.
Yes, we have time for one question.
Oh, okay.
Related to the El Paso Border Patrol case, if your CBA requires you to negotiate over working conditions as well as conditions of employment, does this case change how you should approach union notification over changes in working conditions?
So my first question is, why would you negotiate both of those? No, I'm just kidding. That's just a personal side. I think at this point, if you have negotiated specific language, then you have to test the waters. I mean, what we've learned, I think, from the El Paso and the subsequent cases, can't speak, right, is that it's going to be on a case-by-case basis how the authority carves out. But in this particular instance, you have very specific language, right, that says working conditions will be negotiated. So in my expectation, I would think you really will have to negotiate those until that language no longer exists, because you've tied yourself to something beyond the conditions of employment. Mm-hmm. Do you think? I mean, you could always test the waters, right? We're getting very interesting analysis and decisions out of the authority. This might be the time, but I think, absent, well, the fact is you have very concrete language. I don't really know how you circumvent that.
Yeah, I think that's the risk you take in kind of regurgitating language into your contract, is that sometimes things can change and you still have it in your contract, and so you have to deal with that.
Yeah. All right, so if that's all we have today, but feel free to email your questions to
if we didn't get to your question, we will try to respond via email, or if you just want to reach out to us later with that email address, feel free to, and you can address it to Amanda, and one of us will get it. But we'll turn it over to Marcus to close us out. Thank you.
Thank you.
Thank you, Amanda G. and Amanda J. for sharing your expertise during today's webcast training. Your presentations have provided an outstanding and informative overview of the Federal Labor Relations Authority's decisions. I thank OPM's communications staff for your transmission of the training, and thanks to the AWR team for coordinating this event, and thank you for participating today. We look forward to having you at the next Employee and Labor Relations webcast training. Finally, please remember to fill out the online evaluation form, courtesy of SurveyMonkey.com. Your feedback helps us to plan future webcast trainings, and we appreciate your taking time to complete this survey. On behalf of the entire AWR staff, have a good afternoon.